Hello, welcome to the SCP podcast. SCP is the Society of Consulting Psychology for those of you who are new to our series. I'm Joanie Cannell, and I'm here with my co-host Ryan Warner.
Great. I'm glad to be here.
Yeah, we're going to go with our episode today, which is part of our Fundamentals of Consulting Psychology author series. And our guest today is Dr. Jay Finkelman, author of Forensic Organizational Consulting, The Role of Psychologists in Litigation Support. Welcome, Jay.
Thank you very much. Delighted to be here with you both.
Oh, great. We have so many questions for you, and we're glad that you were able to make it. I have a first question, which hopefully won't be a surprise for you, but I was thinking that forensic psychology all this time was, solving crimes. I'm a crime junkie on TV and all this, but your book is really about the litigation side of it and jury consulting and all that. I was wondering if you could just take a second to tell our viewers and listeners what forensic psychology is before we start getting into your book.
Of course. Well, the forensic psychology, at least as I addressed it in the book, is that portion of psychology that deals with litigation. And it includes everything associated with litigation, from the witness designations, preparations, coaching, and all elements of trials, whether they're jury trials, and how you use mock trials or shadow juries, how you essentially set up a trial to the advantage of whoever is conducting it. And candidly, whatever side has retained you, you're obligated to do what's in their best interest, consistent with truth. So research in forensic psychology or forensic consulting psychology is really the key to doing the right thing for all parties and ensuring fairness at trial.
Oh, well, that's really interesting. And, I'm curious. I know for a lot of listeners out there, they may be interested in writing their own book, in the future. And I want to learn more about your journey. But what motivated you to write this particular book? Tell me more about that.
Well, this is an area that I've been interested in ever since being uh, a debater at Brooklyn College many years ago, and it kind of overlaps with the law. And many people in that position did what I did, which is I applied to law school, took the exam, did very well, decided that that wasn't the direction I wanted to follow, and instead went for industrial, organizational, and consulting psychology. So much of this evolves, and the things that had always captured my interest over time is how juries work, how litigation works, and the role of consulting psychologists in these areas. And that's why, in addition to being a professor and some line management positions that I've had over the years, that is what I've done. I've been an expert witness and a consultant to litigation related materials, predominantly in the employment areas, but they don't have to be. So the principles of forensic psychology could apply to anything in which a trial is going to be required or a possibility.
Excellent. Yeah, well, I'd love to follow up on that. Jay, can you tell us a little bit about what the book is about then, and a couple of takeaways?
Sure. It's a really a practical guide for psychologists, predominantly consulting psychologists, but not exclusively, who are called upon to testify or who intend to testify. And in many instances, it's a desk reference with, I think, vivid case examples and vignettes, basically my own experiences with the clients concealed for ethical and legal reasons, but it's a guide as to how you do it. if you want to branch into what I think is the most exciting area of consulting psychology, which is what brings it into the courtroom.
Yeah, so I think about, just the field of the forensic, consultant psychology, and how that's a, very unique niche and specialty. And then I think your passions and your background really aligns well with, uh, this particular, focus. For those who are interested in growing their experience and learning more about just forensic psychology and, how to serve as a consultant in that role, tell me more about how this book may, be also a great resource for them.
Well, it's really geared both to students as well as practitioners. So people who are looking to see if this is their thing, both from an interest level and from a qualification level, and if they are of a temperament that this is going to be the right thing to pursue. I think the book explores the whole range, both of opportunities, but also requirements and challenges that it entails. So many HR professionals who never considered the implications of the legal system in their practice, the book gives them that exposure. Many psychologists, both clinical, industrial psychologists, social psychologists, who might be interested in practicing in a courtroom environment, this is really a how to do it book at many levels. And although attorneys are a target for the book because the content is of great interest to them, they hire consultants all the time. And there are certain qualities that they have to be aware of, and there are certain things that consultants can and can't do. And I think the book makes all of that very clear in a kind of an interesting fashion with examples of those situations.
When you mentioned it has a lot of appeal to attorneys as well. And I noticed you also wrote the book with Linda Gumberg, an attorney who aided in writing the book. Can you tell us a little bit about what it was like? I mean, this is kind of unique in the series to have a lawyer involved. So what was it like to write with her, and her perspective, how is it different from yours as a psychologist?
Um, it's an important question because my expertise, although I have a master's degree in legal issues, I'm not an attorney and don't have anything close to Linda's expertise or that of most of the attorneys with whom I practice. So it was important, and I was advised by Rodney Lohman, the series editor, that it would be useful to have a legal perspective so that there would be no ambiguity. I'm not giving legal advice. I'm not qualified to give legal advice. And many of the things that I talk about overlap with the legal profession. And we thought it was important to have a real lawyer reviewing material, making sure there are no inaccuracies, and also, to Linda's credit, contribute to the editing of it. So everything was consistent with both case examples and references, which the book is replete with the references, although not obligated to review them as you're reading it for content. But if someone wanted to dig deeper in terms of even the specific cases that I make reference to, that I'm permitted to make reference to, they're there.
Yeah, great. So I think that's really interesting, that having that collaborative relationship, it just brings so many different dynamics and perspectives to the table, which, is definitely really helpful. What opportunities may have, came up after writing this book? Because there's so many individuals, members probably interested in, being authors in the future. How has this helped you in your career, continue to move forward and progress?
If I may, an actual example that I put in the book rather than something that came out of the book. Years ago, I testified for plaintiffs in a fairly high-profile case, and the case went up to the California Court of Appeals, and they made a determination. The jury rendered a $1 million+ verdict in favor of the plaintiff for whom I testified, and the defendants went to the Court of Appeals, and the Court of Appeals said that my testimony had invaded the province of the jury. I think that was their word. And that the judge had made reversible error in permitting me to testify. And the Court of Appeals in California threw out that verdict. The case was retried 3 years later. I once again testified for plaintiffs, and I didn't use the language that seemed to have offended the Court of Appeals, but the jury then more than doubled the verdict, which obviously was good for plaintiffs. The defendants were not pleased that they had appealed this to the court. But the interesting part about that is that it now made HR testimony, human resource testimony, and that is my specialty within industrial organizational consulting, a fully acceptable form of expert testimony in courts. And the old excuse that used to be used that HR is junk science, the Court of Appeals made it clear in a landmark ruling that it can't be excluded as junk science. And in fact, the case was precedent setting. In direct answer to your question, attorneys who read that case decided that if Finkelman could improperly invade the province of a jury, I began getting retained a lot more frequently by both sides, because when it gets down to it, that's what they really want someone to be able to do, to inform and influence the jury using ethical and, of course, legal guidelines. So that was kind of an exciting element that the case still gets quoted virtually every time I testify. So I'm still amused by that.
Wow.
Yeah, that's big. That's more than just your career. That's the career of many psychologists and perhaps the APA in general. That's wow.
Yes, that's very true.
Yeah. I have one last question for you before we wrap up, and that is basically, what has changed if you've been continuing to testify? Are you writing anything new? Is there something you would add, or are you writing something to follow up this book? Or tell us a little bit about your kind of current situation.
Most of the follow-ups have been articles rather than books, although I've written 5 books and 125 articles, and I'm happy to keep writing. But the element that keeps getting reinforced, which I've covered in the book, is something that I'm going to continue to write about, and that's that jurors don't really feel obligated to follow the law. And I've done many juror interviews, and that may upset some attorneys and judges, but jurors will say privately that that is not what they feel that they must do, but rather jurors try to do the right thing, which I think we all respect. And they make decisions very early in a case, often after opening remarks, and then the rest of the trial is spent trying to justify or in rare instances to reverse the decision that they've already made. And hence the jury system, the old saying about the jury system, which seems absolutely true, the jury system is the worst possible system in the world, except for any other system. And that kind of that really describes it. And in terms of what I've found is that as a research-based consulting psychologist, if I know the age, gender, race, socioeconomic status, occupation, and political affiliation of a juror, in at least 90% of the cases, I will be able to determine what their verdict is going to be, almost independent of the facts and issues in that case. So that's extraordinary. And I'm just fascinated by that outcome. And I'm going to explore that further. But multiple regressions have been done in which these elements emerge, and the ability to make predictions, which is then useful for attorneys on both sides and for corporations that are trying to determine, should we litigate this or should we settle? And if we're going to litigate, what is a reasonable amount? That's great information that consulting psychologists can offer because of the scientific and research basis of who they are and what they do.
Yeah, that's powerful. So us as consultant psychologists, we can utilize that knowledge of human behavior, of bias, right, and be able to influence those dynamics within the court system. So yeah, I think
that's exactly right. And you have the key. Bias on both sides is something that consulting forensic psychologists can pick up and use it to try to ensure a fairer trial, or at least advise the litigants as to what's going on and what are the risks associated with litigation.
Definitely. Great. Yeah, this has been really exciting, and I've definitely learned something new today. As we conclude today's episode, is there anything that you would like to leave viewers to think about, or any tips that you can provide?
Thanks for that question. I suppose it would be the fragility of the legal system and the need for, as one Supreme Court justice said nearly 100 years ago, eternal vigilance to make sure that both democracy and the right things prevail. And whenever I review material in terms of juror decision making, I kind of recognize that, and I think it would be wonderful if everyone thought about that and roles that they may play in ensuring fairness in the system. And going back to your comment earlier, the absence of bias, and just recognizing that this does not happen automatically. This requires a level of active intervention and vigilance.
Excellent. Well, Ryan, before you wrap us up, I just wanted to put in a little plug for the author series of the Fundamentals of Consulting Psychology. And you can access those on the American Psychological Association website or at the Society of Consulting Psychology website. Jay, did you want to have people be able to access you as well for either consulting or reaching out?
Oh, certainly. I'm easy to find both through the Chicago School and on my own websites. So thank you for mentioning that. And I'm sure the Consulting Psychologist Society has the email addresses as well. But either through the Chicago School or Dr. J. Finkelman at gmail.com, everything's spelled.
Great. Thank you.
Thank you. Pleasure chatting with you both.
Yeah. And for all listeners, feel free to register for the upcoming SCP conference. It's taking place in Austin, Texas in February. So hope to see everyone there so we can continue to learn and grow from one another. All right. That concludes today's episode. Thanks so much, Jay, for serving as our guest. Until next time.
Thanks, Ryan and Joanie.
Take care.